So before Dr. Shibley discusses today's agenda, I want to tell you a little bit about our presenter. Dr. Mariela Shibley is a clinical and forensic psychologist with a private practice in San Diego, California. She specializes in issues around acculturation, immigration, and trauma, and is a leading expert in conducting psychological evaluations for U.S. citizenship and immigration services and immigration court. She has conducted and supervised over 2,000 such evaluations and provides court testimony, training, and education on immigration and mental health. She's a regular guest speaker at conferences of the American Immigration Lawyers Association and the founder of Psych Eval Coach, an online training program that trains mental health professionals to conduct immigration evaluations. She has recently written a book on the subject that is scheduled to be published in early 2022. So thank you, Dr. Shibley, for accepting our invitation. And to our audience, I'll now leave you with our presenter.
Oh, thank you so much. It is a pleasure being here, and I'm sorry I heard Mercury's in retrograde, and I don't know that I believe any of that, but there's been a lot of miscommunications lately and technical difficulties, so that's why my camera is not showing, but you're not really missing much. So today what I'm going to talk about is I'm going to show you a little bit different statuses of different immigration statuses along a spectrum, and the different ways that an immigrant can adjust their status in the United States, and how, most importantly, how mental health professionals can assist with that. And alongside all that, we will also touch on some cultural and ethical considerations when you're working in this field, or if you're choosing to enter this field. And then I'll open it up to some questions. So hold on to your questions and we will address them at the end. So in the United States today, there are more than 44.8 million first-generation immigrants. That means these are people who were born in another country and came to the United States. 1 in 7 residents in the United States was born outside the United States. The most popular countries of origin for these foreign born individuals are Mexico, India, China, the Philippines, El Salvador, Vietnam, and Cuba. And 1 in 8 US residents is a native-born US citizen who has at least one parent who was born in another country. So the reason why I think also we're presenting this is because with such high numbers, it's pretty common for mental health professionals to have to be asked to do some type of work, either counseling or more along the forensic arena with this population. So let's talk about different immigration statuses. This is a very brief overview, but that gives you an idea. So where along this spectrum, we've got on the far end those who have the weakest rights and benefits in the United States. And on the other end, we've got those who have the stronger rights and benefits. So at the far left end, we've got undocumented individuals. So who is undocumented? Any person who is not born in the United States, who is living in the United States without current lawful immigration status. So that's because either they entered the United States without permission, so they either like snuck through some port of entry, or they entered with a valid visa or other status, and they overstayed the authorized duration of that status. So that's why they currently do not have lawful status in the United States. And the status is something that is granted upon entry. So a person can apply for, say, a tourist visa abroad, and they can give them that visa for 10 years. Well, that doesn't mean that they can stay here for 10 years. Once they enter the country, they get a little card that's called an I-94, and there they get a little stamp that tells them, we're allowing you to stay here for this amount of time. Typical amount of time could be 6 months. Sometimes it's only 2 weeks. So whatever that amount of time is, when a person exceeds that without authorization, then they are here unlawfully. Then we've got individuals who have DACA. So DACA is Deferred Action for Childhood Arrivals. I'm sure you've heard a lot of this. This allows some individuals who are here unlawfully, who were brought to the country when they were children, to receive a renewable 2-year period of deferred action from deportation. So it protects them from being deported. And they're also eligible for a work permit. Now, these people have to meet certain specific criteria, so it's not just anyone. And and there's a lot of guidelines in terms of what year they must have arrived by, and et cetera, et cetera. But this is something that that you might come across as well. Next up is those people who are visa holders, and this basically is any foreign national who's here on a temporary basis, either for tourism, for business, for medical treatment, for academic reasons, certain types of temporary work. So these are people who are not residents, they're not permanently residing here. They are here, but only on a temporary basis, and they have permission to be here. So naturally, they can do whatever it is that their visa allows them to do. In the case of a work visa, they can work. In the case of a student visa, they can study, but they cannot work. So they have to abide by the rules of the visa that they received. And then we come to the lawful permanent residents. And these are people, these are foreign nationals who are lawfully authorized to live permanently within the United States. Now, these people can work, they can go to school, they can't vote though. And of course, there are other limitations to their rights, but they're here lawfully, and as long as nothing goes wrong, they can stay here permanently. And then last on the spectrum, we've got naturalized US citizens. Well, and of course, then naturally born US citizens as well. But in this case, when we're talking about just foreign-born individuals, these are people who, after maintaining lawful permanent resident status for a certain number of years, they can apply to become a US citizen, and they have to go through a naturalization interview, and also some medical tests and fingerprinting and all that stuff, much like for lawful permanent residency. But in this case, they need to pass a test that they can speak a little bit of English, and they have some knowledge of civics and history of the United States. So how can someone become a lawful permanent resident? So the most typical ways are through family or employment-based petitions. So this entails like having a family member who is an immediate family member petition for the foreign-born's permission to reside in the United States permanently. That could be a spouse, it could be a parent, it could be a child over 21 who's petitioning for their parent. It could also be siblings, but those take a very, very long time. So there isn't this real thing about like this chain migration where you just start bringing your aunt and your cousin and your neighbor, and there's no such thing really. It's just immediate family members who are allowed to apply for residency here. And another option is employment-based petitions. And for this is an employer who basically has to prove to the government that no one else in this country can do the job that this foreign-born person can do. And they have different ways of showing that. It costs quite a bit of money. And so naturally, it's only bigger companies who can afford to do this type of stuff. And it's not as popular, I would say, for those reasons, because there's a lot of hurdles. Now, in terms of family petitions, there's also oftentimes a lot of hurdles to overcome. The main one is that for different reasons, a family member or a foreign-born person is deemed to be inadmissible to the United States. There's a lot of different reasons why that could be. The most common one is being present in the United States unlawfully, either because they entered the country without permission or because they overstayed their permission when they entered. So that is unlawful presence, and that is one ground of inadmissibility that is probably the most common that people have to deal with. Another ground for inadmissibility could be fraud or misrepresentation, that is either lying to immigration agent when they try to enter a port of entry, or filling something out wrong in a form sometimes, a wide variety of reasons. And there are many, many different grounds that would make a person inadmissible for to enter or remain in the United States. For that, you will need to prove hardship to a relative in order to waive a penalty, which is basically these people who are inadmissible, they would have to stay outside the year for a period of either 1 or 10 years before they can reapply to be admitted to the United States. And I'm going to go over one example so that you get a clearer picture of what this situation looks like. Another way that some people are able to adjust their status is via cancellation of removal. That is, people who are being deported and can again prove hardship to a qualifying relative in order to be able to remain in the country lawfully. So as you can see, this is not very easy. There are sometimes it's pretty straightforward. You get married, you apply, everything's okay, but oftentimes there are a lot of hurdles in the process. Another way that a person can become a lawful permanent resident is via different humanitarian forms of relief. So one common one is asylum. These are for people who are persecuted or fear persecution in their country of origin based on different types of protective grounds, such as their religion, their political views, their gender, their sexual orientation, etc. There's also special immigrant juvenile status. This is for children, minors, who need to prove that returning to their country of origin is not in their best interest because they will be either abused or neglected. So they need to, this is a longer process, but that basically this is a way for undocumented children to adjust their status and stay in the United States. U visa or T visa. U visa is for victims of crime. This is for individuals who were victims of a crime in the United States or of a crime that violated US laws, and who were helpful or are willing to be helpful to law enforcement for prosecuting the crime. So they need to show proof that they were harmed significantly as a result of the crime and that they helped prosecute the crime, which happened in the United States. So that is a U visa, and people who are granted a U visa are able to stay in the country, and eventually, as long as they meet certain requirements, they can adjust their status to permanent resident. A T visa is for human trafficking, so a little bit different requirements, but ultimately, again, the person has to prove that they were a victim of human trafficking, and if approved, they can remain in the United States lawfully and eventually apply for permanent residency. And VAWA stands for Violence Against Women Act. This is for victims of domestic violence. So this is for individuals, foreign-born individuals who married a US citizen and were victims of spousal abuse. And so they no longer want to stay married to their partner, and are either already separated or in the process of being separated, or have been divorced, and as long as it's within 2 years of the divorce, they can apply for a VAWA, which is a waiver that allows them to stay in the country lawfully without their partner even knowing that they're applying for a VAWA. So whereas like for a U visa, for example, they have to have a police report to show that there was a crime. For a VAWA, they don't need to show any type of law enforcement involvement, and because oftentimes in these cases there isn't one because people are too afraid to call for help. So, so those are some popular humanitarian forms of relief that, again, these undocumented individuals can apply for in hopes to be able to stay in the United States lawfully. So I'm going to tell you a little story about Anna. Anna was brought here by her parents when she was 15 years old. And no, I'm sorry, she was 5 years old. And she was brought here from Brazil. Her parents entered lawfully, but then overstayed their visa. And therefore she never had permission to be in the United States. However, she went to school like all her peers, grew up here. When she tried to get her driver's license, she found out that she was actually undocumented. And this is a very, very typical story for, especially for young children who were brought to the United States when they were very young. And so being undocumented, of course, didn't allow her, prohibited her from a number of different benefits in the United States. Now, Anna eventually met Dan, who is a US citizen, and they fell in love. Dan proposed, they got married. Shortly thereafter, they get pregnant and had a baby. So once they were able to kind of stand on solid feet with all the extra expenses, they decide to petition for Anna's green card. Now she's been here most of her life. She grew up here, she went to school here, she married a US citizen and has a US born child. However, when they go to the attorney to file the paperwork, they get bad news. They're told that because Anna was brought here unlawfully, she is inadmissible. And therefore, she has to serve a penalty of 10 years outside the United States. So this means that either Anna has to return to Brazil, a country she hasn't been to since she was 5, because being undocumented, she's unable to travel. So she technically, basically doesn't really know this country. And most importantly, she has a US born child with a US citizen here in the United States. So either they both have to relocate to Brazil, or they need to separate, and either she will go and her husband and their son will stay, or oftentimes when the children are very young, they make the decision that works the best for them, and so sometimes they go with the parent who has to leave the country. So so basically for 10 years they will be living apart, and which would result in a lot of difficulties for both of them. Now, the government really only cares about Dan's hardships. They don't really care about the child either. They only want to know how Dan would be affected if he had to be separated, or if his wife were not allowed to stay in the United States. So he needs to prove that via a waiver. So a waiver of inadmissibility, as I said before, is something that waives most typically unlawful presence, can also waive criminal grounds, fraud or misrepresentation, etc. A number of reasons why a person is inadmissible. And the hardship waiver, this waiver is granted based on having to prove that a qualifying relative, and this is terminology, that's either a spouse, a parent, or a child, will suffer extreme hardship if this foreign national were to not be allowed to stay in the United States, or if they had to relocate to the foreign national's country, or any other country for that matter, in order to stay together. So this is what's typically known as a hardship waiver. And this is probably one of the most common reasons why individuals seek an evaluation from a mental health professional to help them prove the hardship they either are suffering if they're already separated, or that they would suffer if they were to not be allowed to stay in the country. Now, moving on to humanitarian forms of immigration relief, I went into a little bit of detail prior. We've got VAWA, and again, this is according to the Violence Against Women Act. This is for certain spouses, children, and parents of U.S. citizens, and certain spouses and children of permanent residents who can file a petition for themselves without the abuser's knowledge. Now, as I mentioned before, no police report is necessary. The abuser is never notified in order to protect the victim. And VAWA provisions, even though it's called Violence Against Women Act, they apply equally to women and men and same-sex couples as well. U visa and T visa, again, these are survivors of qualifying crimes who've suffered substantial mental or physical abuse as a result of those crimes. Now, substantial is not something that's very clearly defined, and it's ultimately for the trier of fact to determine whether that rises to the level of substantial or not. And this is where mental health professionals often play an important role. In addition, the victim was helpful, is helpful, or is likely to be helpful to law enforcement in the investigation or prosecution of the crime. The crime has to either have occurred in the U.S. or violate U.S. laws. And as I mentioned before, T visa is for victims of human trafficking. That is for those individuals who were either brought to the United States either against their will, or they were lured into coming under fake, false promises. So typical cases, you're going to come and you're going to work, you're going to have this awesome job, and then they end up restraining them, keeping them, and making them work in hard labor or sex labor, and they are utterly helpless and unable to leave. So for asylum, people need to prove that there was that they experienced past persecution or fear of future persecution if they had to return to their home country, and the persecution must have been perpetrated by either the government or individuals that the government is unwilling to or unable to control. And the persecution or torture is on account of a person's race, religion, nationality, membership in a social group, political opinion, etc. Now, if they don't qualify for asylum, they can also qualify for things along those same lines, which one of which is called withholding of removal. For withholding of removal, basically they just have to prove that they will be more likely than not suffer persecution if they were removed from the United States. And even though they can remain in the United States for the time being, they also receive less benefits. So whereas with asylum, they can eventually adjust their status to permanent resident, that is not the case with withholding of removal. The other similar benefit, it would be its Convention Against Torture. And so basically for this, they need to show that they will more likely than not be tortured if they were removed to their country. And unlike asylum or withholding of removal, this is not on account of their race, religion, or anything else. But it's But again, they need to prove that they will be tortured if they were removed to another country, and they have even less benefits than people with who are granted asylum or withholding of removal. Special immigrant juvenile status is available to certain minors who've been abused, neglected, or abandoned by one or both parents. They have to be under 21 and unmarried. And basically, all they need to prove is that it's not in their best interest to return to their country of nationality because it's unsafe for them. So how do mental health professionals play a role here? One of the most common roles that we come across and that I spend a lot of time in is doing psychological evaluations. So one of them is assessing the emotional and psychological hardship to the qualifying relative. So in Anna's case, Dan would be the one coming in to see me and undergoing an evaluation so that in my report I can determine the likelihood that he will suffer if he had to be separated from his wife or if he had to relocate in order to be with her. So that's called, while they're still here, they're still in this country, that's called a provisional waiver. So basically it's telling them like, yeah, we'll likely waive this ground of inadmissibility. You still have to leave the country to go to the consular interview in the immigrant's country of birth. So for example, if the person is from Mexico and they're still here, and that interview that you see in a lot of movies where they, you know, sometimes separate them and such, and they ask them about the color of their toothbrush, it's really not like that, but they do undergo an interview like that. And those people who are here unlawfully, they have to, technically, that on paper they're not here, and so they need to go back to their country of origin and go do the interview at the US Embassy over there. Now the problem is that this 10-year ban, or 1-year ban if they were here for less than a year, I'm sorry, 3-year ban if they were here for less than a year, that kicks in as soon as they leave the country. So it's kind of like, you know, it's tricky because they're here, like Anna's here, she's, you know, she has a husband, she has a child, she has family here, and she wants to adjust her status, but it's basically, do I stay here unlawfully or do I leave and then not be able to come back? So in 2013, they this new policy came out that those people who know that they're going to need a waiver can apply for it while they're still in the United States. But this only waives unlawful presence. So those who need a waiver for criminal record or for fraud or anything other than unlawful presence, that's not for them. Those people need to leave, and then once they're outside the country, then they can apply for a waiver. At any rate, what they need to prove is the same thing. That is that their qualifying relative, again, that is depending on what type of waiver it is, that varies, but in general, it's typically either a spouse or a parent of the applicant. So in some cases, it could be the child. But in cases of unlawful presence, for example, for a provisional waiver, a child is not a qualifying relative. So same thing for cancellation of removal. People who are in deportation proceedings, they also need to demonstrate that they're being forced to leave the country would result in extreme, well, significant hardship to their qualifying relative. Now there's a lot, this is very intricate. It's not as simple as I am describing. But in a nutshell, what the mental health professional typically does is, in this case, evaluate the qualifying relative in order to substantiate their claim of suffering. Mental health professionals can also be very helpful when they are called to evaluate the psychological impact of trauma, such as cases of asylum, U visas, T visas, or the special immigrant juvenile status. With asylum, forever, there's a caveat, and it's that oftentimes, even though people think that that's what they are evaluating, is the psychological impact of trauma, most of the times that I've been asked to evaluate asylum seekers has been for issues around credibility. So in a way, it is, again, demonstrating how they've been impacted by the trauma they experienced, but most importantly, why, to explain maybe some inconsistencies in their declarations, or issues around credibility where they're just not credible. And so the trier of fact wants to understand what's really going on. So that's for cases of asylum. Another way that mental health professionals play a role is if they need to assess competency. Substantiating claims of spousal abuse. And that's for VAWAs, as I explained, but also U visas. So if the abusive partner, for example, is undocumented, then the person can't apply for a VAWA, because VAWAs are only for spouses of US citizens or US residents. And so you'll see many cases where the victim is undocumented, both the victim and the abuser are undocumented. And so that would fall under the U visa rule. And now in this case, unfortunately, they do have to have proof of law enforcement involvement. So unlike the VAWA where they don't, a U visa, they do need to have a certified form from law enforcement certifying that this person was indeed the victim of a crime. And something similar to VAWA is removal of conditions. So basically when a person, when a foreign-born person gets married to a US resident or US citizen, initially they get like a temporary green card. And then 2 years later, so it's a conditional green card. 2 years later, they need to prove a certain number of things. So basically that they're still together, and that, you know, just to make it very clear that this was a legitimate marriage. And so at that point, these conditions are lifted and the person can have a permanent resident status. So in situations where the couple separates within those first 2 years, they need to be able to explain why they should still have their conditions removed and be allowed to stay here permanently. And most of the time, that is due to spousal abuse. So it's similar to a VAWA in terms of what the evaluator is assessing, but the legal case is a little bit different. Another way is to assess competency, which is very different than competency in federal or state law. The bar it's much lower, and basically is to assess whether the defendant can represent themselves without the aid of legal counsel. And so basically, if they understand the charges against them and how to defend themselves, basically. And so otherwise, if they're deemed to be incompetent, they will be allowed, they will be granted legal representation free of charge. Because unlike, you know, in federal cases where we've got federal defenders or public defenders who are assigned to a person undergoing any type of criminal proceeding, in immigration, that's not the case. So they need to prove that they are incompetent to represent themselves. Otherwise, they're either on their own or they need to pay for an attorney to represent them and help them through the process. And those, just to add one more thing about the assessing competency, typically those are done in detention centers because these people are detained at the time. Another way that mental health professionals play a role is evaluating the risk or rehabilitative potential. So these are cases. One of them is called the Adam Walsh Act. This is for individuals, for U.S. citizens who have been, who are registered sex offenders. And they, in those cases, that's, I always laugh because it's like the only case where they actually really protect the immigrant. And so basically a person, a U.S. citizen who's a registered sex offender cannot petition for a spouse to, or for a relative to get their permanent residency because they don't want, they want to make sure, you know, that the foreign nationals are not going to be placed in danger and taken advantage of. So, so these people, and now a lot of these cases are either they're 30 years old, some are statutory rape, as in a guy who was, I did a guy who was 20 years old and was dating someone who told him she was 18, turns out she was 16, and then when they broke up, she was really upset and her parents reported him to the police for statutory rape, and so he was, now he's a registered sex offender. So a lot of cases like that. And so usually for those, it's, in my experience, it's only psychologists who can do that type of evaluation. Same with competency, because of the testing that's involved. And yeah, I think it's mostly psychologists who can do those evaluations. But also there's evaluating risk in cases of bond. So if a person is detained and they want to be released on bond, they need to prove that they are not a risk to society. And oftentimes, you know, it's has to do with substance use, etc. And so again, these are a little bit more intricate evaluations. They are typically done in detention facilities, and yeah. And then lastly, there is certifying disability exemptions. So as I said, for foreign-born person who wants to become a naturalized U.S. citizen, they need to prove that they speak a little bit of English and have some knowledge of U.S. history and civics. And so if they cannot, they need to have either a psychologist or a physician or a DC, who's typically a chiropractor, but I'm sorry, DO, anyway, a physician, fill out this form. The form is called N648, so that's short, basically, for what they need. And so this is, again, different type of testing involved. It does not involve writing up a report. It just involves filling out this form to very, very, very carefully. They will deny these forms if you just did not put NA, as in not applicable, under a question that's, you know, that didn't apply, or if you just, you know, put TWO instead of TO. I mean, it's ridiculous, the reasons why they deny these forms. So so it's not an easy thing to do. The person has to really, really be knowledgeable about what immigration is looking for to fill out these forms. And as I said, these can only be done by psychologists or physicians. Now, there's a lot of other ways to assist if entering a forensic arena is not your cup of tea. One way is to work with the applicants or the qualifying relative and to be in therapy with them, and then provide an affidavit of support. So basically, it's just a letter. You're not doing an evaluation, because ethically you cannot evaluate your own patients, but you can provide a letter of support, just stating basically anything you want. It could be as simple as, I've been treating this person for this many months or this many years, and they're showing progress, but they need to stay in treatment. That's great. It could be explaining their disability or their mental disorder. It could be, this is why a separation from their spouse, for example, would affect them. So it could be as short or as long as you want, but it's not an evaluation. It's not a report. And but oftentimes it can be extremely helpful to substantiate the applicant's claims. And of course, treatment, working with these individuals. And we'll talk a little bit more about the cultural considerations in a second, but first of all, a lot of times the people who are undocumented or who have family members who are undocumented are very hesitant to seek out mental health treatment. And a large part of that is because of the stigma associated with it, and because of cultural beliefs. So when you're thinking of having a niche, for example, it's important to consider that this particular niche, which is like reaching out to those people who are less likely to seek you out for treatment, and offering services that are adequate for where they are in life. Another way to help is by running support groups. I am a volunteer at a free clinic through the University of San Diego. Have been doing that for many years. And one of the things that I've done was running support groups. The free clinic is for people who, mainly for people who are just don't have insurance and are undocumented. And so these support groups ranged from just your typical, support group to also psychoeducational groups where, perhaps we talk about coping with anxiety and with stress. And, with the previous administration, we had to do a lot of groups normalizing their situations of the immigrants and their loved ones and their fear, and coming up with action plans, in case of worst case scenarios, as well as, solidifying their protective factors. So that's another way to assist. Now, a lot of people, when they're interested in helping, foreign-born individuals or their loved ones, they often ask, well, but I only speak English, so do I have to speak a second language? And the answer is absolutely no. First of all, there's interpreters. So if you need to employ the help of an interpreter, of course, it would have to be a professional interpreter, cannot be a family member. I used to be an interpreter in my previous life, so I happen to know a lot about interpreting and what the requirements for certification and all that stuff. And so I'm very specific when it comes to hiring an interpreter. But basically, that will facilitate the work with an individual who doesn't speak, whose language you don't speak. But also, and most importantly, as I said before, like in the case of Anna and Dan is a US citizen and he speaks perfect English, and he is the one who would be coming in to see you because he needs to demonstrate that he would suffer extreme hardship if he were to be separated from his spouse. So a lot of these evaluations, a lot of our patients who come in for treatments are actually either people who were either born here or who've been here for a very, very long time and speak perfect English. So absolutely not a requirement to speak a second language. Do you have to be licensed? Well, it depends on what you're getting involved in. In some cases, for example, the N648s, that's for the exemption for disabilities, you absolutely have to. Not only that, but you also have to have a specific type of license. In other cases, such as in evaluations, it's preferred. I would say that in those evaluations that are adjudicated in court by a judge, and there is a potential for testifying, in general, it's you know, you would want to be licensed. Doesn't necessarily limit it to a particular degree. I think people who, in my experience, to my knowledge, master's level clinicians tend to sometimes have to really defend their qualifications in court. But you know, honestly, that is true for all of us. They'll get you however they can when they're trying to you know, to diminish your credibility or your, you know, your status. But I train people in my practice. I have psychological assistants who are doctorate level clinicians who are working towards licensure, and they do the evaluations. I supervise all their cases. I co-write the reports, and they are not licensed, and they do evaluations just fine. Of course, with me as a co-signer. For those people who, again, are under supervision, they can do the evaluations, but also treatment. They absolutely can provide therapy services to anyone under supervision. And in some cases, you don't have to be licensed at all. Like if you're going to be doing some community work, like you could even do, you know, psychoeducational groups or meetings, lectures. And you know, most importantly is a lot of people, one of the questions I got asked a lot is how can I help? And it feels like such a steep mountain because it's so like foreign to, you know, to a person who you know, who doesn't interact much with immigrants or their loved ones, that they think, you know, they have to run to the border and, you know, work with asylum seekers, and that couldn't be farther from the truth. There's a lot of different ways to be involved, and at a macro level, at a micro level, is so important to normalize situations. So for example, you're working with someone whom you know who's born in another country and is an immigrant, and you know, just asking like, oh, so do you have a green card or are you undocumented? Like it's no big deal, right? Same as, you know, when you're asking a new mother, are you breastfeeding or are you using the bottle? Like, making it like, well, you know, you could be either and both are fine, right? To normalize it that way. So, because one of the things that individuals really struggle with is like carrying this like big, heavy secret that they don't want to share out of fear, naturally, that, you know, they will, worst case scenario, get deported, or best case scenario, you know, just be misunderstood. So being able, you know, understanding and educating yourself that, you know, people who just don't have a permission to stay in the country does not mean that they are, you know, that they're criminals or hurting anyone in any way, even though they often feel like they do have to keep it a secret. So just normalizing it is huge when it comes to working with this population. Nowadays, because of COVID, this was a huge adjustment to working via telehealth, but we've made it work. You, of course, always have to follow the current guidance from the Department of Health and Human Services, and you know, within your state, your particular state, because it changes. You know, it's been changing a lot lately. So, and of course, it's always encouraged to use HIPAA compliant platforms. But and you know, there's some things that of course you cannot do, some tests that you cannot administer that that you typically do in person, but you in other cases it shouldn't be really a problem as long as you adapt to it. And the final question, do you need special training? Well, yes and no. You have to be competent. We know that this is from the ethical guidelines for psychologists, that this is true for any other mental health professional. You cannot provide a service for that you do not have any education, experience, or training in providing. And so a lot of people think that, oh, well, I'm a therapist, I can do that. And it's not so much what you don't know in terms of what needs to be evaluated, but it's also what you don't know in terms of what can jeopardize a person's case. So, for example, not going to get into too many details, but I just recently came across a report. The attorney referred the person to me to redo an evaluation that somebody else did because they wrote on the report something that was incriminating for the applicant. And you know, and it's something very simple, like, oh, she came on a student visa and she got a job to make ends meet, and it's like, uh-oh, that will get you in trouble because you're not supposed to work when you're on a student visa. And so that will add yet another layer that they need to explain, and possibly another ground of inadmissibility that they need to waive in order to be admitted to the United States. So little things like that. Immigration is, after tax law, the most complex law in the country. As Doris mentioned, I just finished writing a book on conducting immigration evaluations, and I had the help of an immigration attorney to write all the legal portions of it to make sure everything was accurate. And I've been doing this for about 14 years. And there were so many things that I was surprised that I didn't know. So it's so complex, so many exceptions, so many, you know, nuances that that is really, really important to be aware of if you're going to enter this field, because you know, at best it won't be helpful, at worst it can really jeopardize a person's case. So with that said, I would like to open it up to questions.
Thank you, Dr. Shibli, and thank you for a wonderful presentation. We do actually have a few questions.
Okay, great.
So I will share some of those with you. Hopefully we'll have enough time to answer all of them. The first one is, can you clarify the difference between asylee and refugee?
Okay. So it's basically the same thing. An asylee has to meet refugee status, which is what I described, that they are victims of persecution or fear of persecution in another country. The difference in terms of when they're so a refugee technically is a person who seeks admission to the United States in another country. So a lot of immigrants from the Middle East, for example, first they are typically taken to another country, a third country, where they stay in refugee settlements, and it is there where they undergo interviews and and they are determined to meet the criteria for a refugee. And so then when they enter the country, they already enter as a refugee because they've been approved outside the country. An asylum seeker is not either hasn't entered the country or is already in the country, but they didn't enter as a refugee, and so they're applying for that refugee status. And so that's why they're seeking asylum in order to be able to stay in the United States as a refugee. So I think that's the simplest way to describe it without going into a lot more detail about the different types of asylum one can seek and such. But I hope that answers your question. If not, let me know.
Thank you. Thank you so much. We have another person that says, hello, thank you for your presentation. And the question is, if a couple is legally faithfully married with a baby and the husband cheats on the wife and they want to end the marriage, can the wife still file for LPR? Thank you.
Cheating is such it's difficult because technically what they need to prove is that they suffered harm, that they were harmed, either physically, sexually, emotionally, and but most importantly, I think the threshold there would be to prove that they were victim of cruelty. So I think that the treatment has to be cruel. So for example, a person who cheats and is caught and then that ends the marriage is different from the person who cheats and the partner finds clear evidence and yet they're told, no, you're crazy, you're imagining things. Because then now we're getting into emotional abuse, gaslighting, and that's pretty serious stuff. So in that case, even though there isn't like physical violence and really ultimately it's cheating, but really what it is the emotional abuse. But in a case where I just happened to meet someone and liked them better and didn't just went ahead and cheated, then if that's what ended the marriage, I think that might be harder to prove in order to either get a VAWA or now for removal of conditions. However, oftentimes what immigration cares about the most is whether the marriage was legitimate. So I've had several people who've come in and they weren't necessarily victims of abuse per se, but they genuinely wanted to stay together with this person. They're extremely distraught about the marriage ending. And that's what the attorney wants to show to immigration, that it was against their wishes, that that they meant to stay together, basically. And so and they have to present, of course, other evidence, maybe that's unrelated to psychology, as to why they should be able to be granted a permanent residency. But that's for those who have a conditional residency, those who separate within those first 2 years since applying for the green card and who already have a conditional green card.
Thank you so much. We have another question. Are there any potential protections for victim survivors of gun violence or domestic violence in their home country?
That they were victims of gun violence in their home country? Protection.
I'm sorry?
I don't understand the question. It's like, is the protection within their country, or was the violence in their country and the protection in the United States?
Exactly, the second one, the violence in their home country and the protection in the US.
Yeah. So one of the things for for asylum, one of the rules that the protected grounds is participation in a social group, and that typically involved gang-related violence and domestic violence. Now, I don't know where things are right now because things are so in flux with immigration. I know that a few years ago, the Attorney General had said, you know, no more victims of domestic violence and gang violence are not deemed to be, you know, under protected status. But I know that there's been a lot of litigation on that, and I'm not sure where that stands. Have I evaluated victims of crime in their country that was perpetrated by gangs, you know, the cartel? Yes, that's a lot of it, and that falls under a group that the government cannot control area, and so in those cases, yes, they can seek asylum based on that.
Okay, thank you so much. So I'm gonna go to another question that's been asked by more than a few of our participants. Could you give us more information regarding the trainings and the process for professionals interested in entering this field of evaluation?
Yeah, so I know I started my own trainings in when COVID hit, and because initially I had more time and I embraced Zoom. So that's when I started them. I know that there are other trainings. I can't really say much about them because I have not taken them. I know that some of them are in person. These days, I don't think there are any really going on in person, but most of them I think are pre-recorded. My trainings are live, and so this is Psych Eval Coach is the name of our trainings. There are a couple of books. There's 2 books in the market now on conducting evaluations, mainly for evaluations in this field. The reason I wrote my book was because I wanted it to be very accessible to all kinds of mental health professionals. Like one of the books is called like Forensic Evaluations for Immigration Court, and you know, the evaluations that I do are not always adjudicated in court, and I don't use the word forensic because I don't want to scare people away, and it's written in a pretty like clear language. It's not out yet, but and there are some articles that I've come across that just kind of tackle like separate issues, you know, so they're not like all encompassing. By no means they will like train you to do this, but it is they are very informative and worth reading. I can't really name any at the top of my head, but you could do a search for that. But yeah, I hope that answers your question.
Thank you. And we had mentioned that if there's interest from our audience, we would be more than happy to provide a second webinar with more detail on the process of evaluation for immigration processes. So we have another question. This person asks, who typically pays for these services? I'm wondering how the families who are dealing with these issues have money to cover lawyers, psychologists, etc.
Yeah, that's a great question. So unfortunately, for most cases, it is the client who pays for all the legal costs and the cost of the evaluation. Things can get really pricey. Not only does the person have to, you know, those who retain the help of an attorney, they have to pay an attorney, and that's expensive, but also immigration filing fees just keep going up. This is a reason why you often get like families who have, you know, been married for years and just put it off because it is so expensive. So in terms of the evaluations, as much as I would love to do them all for free, and I still hope that someday I will be able to, while still, of course, making a living, reality now is that I cannot I cannot do that because I do have a family to support, and but I do I set my prices at a number that is realistic for the applicants, for the clients to afford. This is why a lot of people actually turn this type of work down, because people in the forensic arena, or even like who do like psychoeducational evaluations, they're used to charging thousands of dollars for an evaluation. And whereas some individuals charge above $1,000, I've heard of like a $2,000 evaluation for an asylum applicant, which I think is outrageous. But some people do charge a lot. I don't. I have a set fee, and of course I'm in San Diego, California, so it's all according to your cost of living. So me giving you a number is not really going to say a lot, but just keeping in mind where people are coming from, their resources is super important in this type of work.
Thank you so much. Okay, we have another question. If a rancher wants to get legal status for his workers, what requirements do they need to meet for both the rancher and the worker? Rancher, someone who owns a ranch.
Rancher. Oh, I don't know, because that's a whole different area that I never get involved in, because these are like employment-based petitions. I do know that I had someone, and this is how crazy immigration laws are in this country. So I had someone who was here studying for her MBA. She's from Spain. And I hired her as my office assistant and, like an office manager. And so she worked for me during the 1 year that's called OPT. I don't know what it stands for, but it's basically the 1 year that they are allowed to work after they finish their schooling. And within that year, we were really trying to get her to stay, and I looked into sponsoring her, and I could not do it. It was, I think first of all, the company has to be worth a certain hundreds of thousands of dollars, I think. But the requirements, I did not meet the requirements. So I know that it's not easy. As a side story, what ended up happening is she actually fell in love with one of my psych assistants, who is a U.S. citizen. They got married, and they are still here, and they have a baby. And her best friend that she came with to study the MBA was not as lucky. She did not meet anyone, so she had to return to Spain, and she is now working in Spain for an American company who is sending American dollars over to Spain to pay for this person that the U.S. trained, but would not make it but she wasn't able to stay in this country. So this is how great laws are. Yeah.
Okay. Someone is wondering, are there any organizations where professionals can volunteer to do this type of work?
Yes. So again, I don't know what's in other states. Here we have Survivors of Torture International. I would assume they're all over the nation, but they mainly deal with asylum seekers, and they provide, they're a nonprofit, and they oftentimes, like, they outsource when it comes to the evaluations, and it's either they look for either pro bono or low bono. I do work for them. But again, as in, like, with most people, we can't just do it all pro bono. So, I have a set number of cases that I can do for them, pro bono or low bono. So that's the Survivors of Torture International. There is also the Immigration Justice Project. Again, I don't know if that's I guess the bar is the California bar. It's part of the California bar, but you can Google it and see if they are in other states. And what they do, it's a really, really cool nonprofit that they train attorneys for free to represent individuals in immigration proceedings. In exchange for, they have to do have to take on a number of cases pro bono. So they get the training and they give back by taking a couple cases pro bono. And I've done some work for them, pro bono and low bono. Unfortunately, like what I've been trying to start this for years, which is something similar, which is like I'll train, and in exchange for, you know, providing services free of charge to people in immigration proceedings, but we haven't been able to get that off the ground yet. But yeah, so those are two that come to mind. I know here we have a place that's called Casa Cornelia that also mainly focuses on asylum seekers or victims of human trafficking. I don't think that is a national institution, but you can do a search and look for nonprofits that help undocumented immigrants.
Great. And I see there's a National Immigrant Justice Center for those of you who are interested. The one you mentioned in San Diego, that's a national as well. Unfortunately, we're out of time. So again, I would like to thank Dr. Mariela Shibli for this wonderful presentation. And I think, Dr. Shibli, there might be a slide prior to this one or after this one.
Yes. And this is my email. If you have any questions that I didn't get to answer, feel free to send me a direct email to that address. And here is the other slide.
Yes, thank you. Thank you so much. So for our participants, we do have an evaluation. You have the QR code and you have the link for the evaluation. This will allow us to continue to offer training such as this one. So we would truly appreciate it if you can take it. Takes a couple of minutes to complete the evaluation. So thank you, Dr. Shibli, and thank you to all our participants for your patience with our technical difficulties and for participating today. Thank you so much.